So in this unit, we're going to go into a little bit more detail about how the various court systems function and also the specific procedures that you have to go through in filing both a civil suit and a criminal suit. So there's a lot of detail here. It's a little complicated, so see if you can stick with it. So first of all, with regard to trial courts, remember in the last unit we talked about trial, appellate, and Supreme Courts. What we talked about is that trial courts are about determining the factual issues that are in play and in contestation in the particular case. So trial courts are primarily about adjudicating facts based on whatever the settled legal principles might be. And it's important to understand that you can have a trial that's only before a judge, or you can opt for a trial by jury in a civil case. At least in most civil cases you can do that. If there's a jury trial going on, then the judge has a very specific role. The judge is to be the arbiter of the law, but the judge is not supposed to be deciding the facts. That's really for the jury to determine. And we'll look a little bit later about the way in which the judge plays the role of adjudicating the law and making sure that the procedures of the case operate correctly. But the province of finding the facts is for the jury, at least in situations where it is a jury trial. As I said earlier, you could have a judge trial, in which case the judge is the finder of the fact. Appellate review, we also talked about. The court only then looks at whether the procedures of the court were followed correctly by the trial judge, and also whether the law that was applied was correctly applied. The appellate review is deferential. So even if the appeals court thinks that the trial judge made a few mistakes, they generally are going to defer to the trial judge because otherwise every case might get overturned on appeal and sent back, and then you would do it over and over again. So the standard for most decisions that a trial judge makes is abuse of discretion. So as long as it's generally within the discretionary power of the judge, if the judge rules one way on a motion instead of another way, usually an appellate court is not going to revisit that decision unless it's a clear abuse of discretion. That's with regard to the procedures connected to the trial, but we also need to understand that sometimes there's a question that's a matter of law. What is the actual law in this area? And on that, the appellate court can exercise what's called de novo review. And de novo review means new review. They don't have to defer at all to what the trial court said. They can reopen the question of whether certain sorts of behavior qualify as a tort, for example. We're going to look at torts later on in this course. Certain sorts of behavior might qualify as a tort or not qualify as a tort. That's a legal question. That's not a factual question. Then the factual question is, did the defendant actually engage in that behavior? But the first question is, what does the law say? And on the question of what the law says, the appellate court gets de novo review. And then finally, the Supreme Court, and we talked about this, generally has discretionary review. They don't even have to agree to hear a case. And as I mentioned in the last unit, the US Supreme Court only hears a very, very small fraction of the number of cases for which parties file a petition for certiorari. And so generally, it's a very small slice of the cases, and only cases where the Supreme Court not only might think that there was an error, that's not a good enough reason, but also the court might think it's an important issue of uniformity. It's an important issue for the entire federal court system to operate as one on this particular issue. And those are the situations where the Supreme Court would hear a case. There is a small category of cases that are within the Supreme Court's original jurisdiction. They're not wildly important. They generally have to do with disputes between two states. And in those kinds of cases, the Supreme Court actually sits as a trial court to hear the case under the US Constitution. And so that's the original jurisdiction of the Supreme Court, but that's a very, very small minority of the cases. Okay, so let's look at civil suits. As we said, these are cases brought by one private party, either against the government or against another private party. And to commence a civil suit, you need to have what's called standing under the Constitution. And that's a requirement under Article 3 of the Constitution. It's what gives courts the power to hear the case. So you as the plaintiff have to actually have been harmed by whatever it is that the defendant supposedly did. So if you want to challenge something that someone else did, you can't just be a bystander who saw it happen and think, oh, well, you know, that's something that I think is a problem, let's go sue about it. You actually have to be the person who was harmed by whatever it is that the defendant did. And you either need to already have been harmed, or you have to be in immediate peril of being harmed in order to have standing to file that suit. Otherwise, the suit will just get dismissed for lack of standing. Once the suit gets going, at least in federal court, it's adjudicated under something called the Federal Rules of Civil Procedure. This is a large number of very detailed rules. We're not going to go into all of those details, but you just need to know that you would need to follow the Federal Rules of Civil Procedure in a federal court, or if you were in a state court, every state has its own rules of civil procedure that you would need to follow that would tell you all of the details about how the case needs to move forward. And I mentioned in the last unit, we refer to a plaintiff and a defendant in a civil suit. The plaintiff is the person who says, I was wronged. The defendant is the other party that supposedly was the wrongdoer. And the plaintiff has the burden of proving that the defendant did the thing that was wrong by a preponderance of the evidence in a civil case, 51% more likely than not. All right, so how do you start a civil suit? You file what are called pleadings. And the first pleading that is filed to start a suit, to get it going, is called a complaint. And it is governed by Rule 8 of the Federal Rules of Civil Procedure. And the complaint doesn't actually have to have that much information in it, because often a plaintiff doesn't know that much at the time that the complaint is filed. But it has to have a short and plain statement of the claim, and it needs to have a request for relief, what it is that the plaintiff is asking the court to do. And the law that the plaintiff thinks that the defendant has violated. But again, it just needs to be a short and plain statement, and it may be that at that point, the plaintiff doesn't have much evidence, for example, because it will take the trial process to develop the actual evidence. They just need to have enough to get things going and to give the defendant fair warning about what this lawsuit is really about and what the grounds for relief are. So the defendant, having received that complaint, then has a certain number of days to file what's called an answer to the complaint. And the answer to the complaint, also governed by Rule 8, usually ask the defendant to either admit or deny the various allegations that are made in the complaint. And usually there are some facts that are in the complaint that the defendant admits freely because they're not controversial. But there will almost always be something that the defendant will deny, otherwise there wouldn't be a basis for having a lawsuit. And so the defendant would file that answer, and that would help narrow down what really is in dispute in this case. So for example, you could imagine a contract case. And as we'll see when we do our unit on contracts, there needs to have been a contract that's formed, and then there needs to be breach of the contract. So you could imagine in a particular lawsuit that there's no dispute at all that there was a contract formed, but there's a big dispute about whether there's a breach. So the defendant might admit that a contract was formed, but then deny that the defendant breached the contract. And it would help narrow down the issues that are actually at play in that lawsuit. In some other lawsuit, you could imagine someone would say, no, 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 we never formed a contract at all. And so we never even get to the question of breach. So it's important to have the complaint and the answer so that we can know what's really in dispute in this lawsuit. It's also the case that the defendant could file what's called an affirmative defense. We will talk about some affirmative defense in both contract and tort actions in subsequent units, but basically the idea is, yes, I did this bad thing that you say I did, but I have a justification. So for example, yes, I hit you, but I did it in self-defense. Or, yes, I signed this contract, but you had a gun to my head when I did it, and so I did it under duress. These are sorts of affirmative defenses that the law recognizes, and so, again, if you were filing your answer, you might also file your affirmative defenses, saying, here's what I admit, here's what I deny, and here's things that I admit, but I had a justification for doing it. I have an affirmative defense. And with regard to affirmative defenses, the defendant has the burden of proving it. So if the defendant wants to say, yes, I signed the contract, but you had a gun to my head, the defendant's the one who has to prove that the gun was to his head. In addition to an affirmative defense, a defendant could file a counterclaim. And a counterclaim is different from an affirmative defense because an affirmative defense is saying, yes, I did this bad thing, but I had a reason. The counterclaim is something different. The counterclaim is, I want to sue you back. So you're suing me, but I actually have a claim back against you. Maybe you caused me a harm, or maybe you breached my contract, or something like that. And so I'm basically bringing a separate claim against your claim. And that functions almost like you're filing your own complaint. You have the burden of proof. You have to plead and prove the elements of your counterclaim as if it were just a complaint that was filed in the first instance. And the idea of that is it just puts into one litigation package all of the things that the two parties are mad at each other about and allows us to resolve them all in one. The final thing that a defendant might file up front in response to the complaint is a motion to dismiss. And that's governed by Rule 12b of the Federal Rules of Civil Procedure. And we're not going to go through all the different provisions of 12b, but you could, for instance, say, oh, this case should be dismissed because this court is the wrong court. It doesn't have jurisdiction. We'll talk more about jurisdiction soon, but you might say that this is the wrong court for this lawsuit to go forward. In addition, you might file what's called a 12b-6 motion. And that's a motion for failure to state a claim upon which relief can be granted. Failure to state a claim upon which relief can be granted. And the idea here is, even if everything that you say in your complaint is true, even if I did every single thing you say I did, it's still not a violation of the law. And so basically this case can be dismissed without even going to trial because whatever it is you're alleging, it's not unlawful. It's not a tort. It's not a breach of contract. It's not a violation, whatever it might be, even if every single thing you say is true. And so there, you could imagine, I could admit every single thing you say in your complaint and then file my 12b6 motion and say, so what? All of those things, maybe they're not the nicest things in the world, but they're not unlawful things. The 12b6 motion is a motion that where the judge would rule up front that as a matter of law, there's no case here. There's no claim. All right, so let's assume we get past the 12b6 motion and the judge says, no, we're not going to dismiss. There's at least a genuine issue to be potentially worked out at trial here. Assuming everything that the plaintiff says is true, there's a violation of the law here. Okay, so now the question is what the plaintiff says in the complaint actually true? Can the plaintiff actually prove it? And so the next step in the trial process is to go to what's called discovery. And this is a period of time when each side asks the other to present and provide information that is relevant to the lawsuit. It has to be material that is not otherwise confidential for various reasons, and there's a lot of different discovery rules and nuances which we're not going to go into, but what you need to understand are sort of the basic discovery devices. So you can ask the other party for, through interrogatories, you can ask them questions which they have to answer in written form. You could ask them to produce documents, emails or ledger sheets or contractual documents or maps of the building or whatever it might be, depending on what the lawsuit is about. You can ask them to produce stuff. And then the other big one is depositions. Depositions are questions of potential witnesses that are done under oath. And they're usually now videotaped, so they're preserved. And so you would ask for information from perhaps the other party or from potential witnesses, and that would allow you to find out more about your case, but it would also allow you to freeze that testimony so that if, for instance, by the time we get to trial, that person is no longer available, maybe they've died, something like that, we have that testimony. And even if they are still available, it means they can't testify at trial to something different than what they said under oath during the discovery process. And so it allows both sides to know what actually is the evidence that's likely to be presented at trial. How good is my case? Do I think I'm likely to win or not? Because maybe I might want to settle the case or something like that. All right, so you get to the end of the discovery process, and at that point, one or both parties can file what's called a motion for summary judgment. And here, the idea is, look at all of these facts that exist in the case. These facts are not in dispute. These are the ones that are fully developed and there's no dispute about them. Based on those facts, as a matter of law, I win. Could be the plaintiff, could be the defendant, but that's the idea behind a motion for summary judgment. And a judge gets to decide that. Now remember, that's kind of interesting because we already said judges are not supposed to decide facts. Juries decide facts, right? So how can a judge rule on a motion for summary judgment when, if the judge rules, let's say, either for the plaintiff or the defendant, then that case is never going to go to trial So there will never be a jury deciding the facts. So essentially, the judge ruling on summary judgment is taking the case away from the jury. Well, if the jury is the one that's supposed to find the facts, then the motion for summary judgment can't revolve around a factual dispute. Because if there's a factual dispute, that should be decided by the jury. If the dispute is only a question of law, then that case can be decided on summary judgment by the judge. So let me give you a concrete example because it's a little complicated to figure out. So let's say we have a situation where two cars are driving and they get into a car accident. Okay? So if the issue was the defendant speeding at the time and therefore driving negligently, and the dispute is whether or not the car was speeding, then you have a dispute as a matter of fact. You know, was the car speeding? Was it not speeding? You've got a witness that says no. You've got a witness maybe that says yes. You have a dispute about the fact of whether there's speeding. If there's a dispute about that, that has to go to a judge. But you might have everyone agreeing that the person was going 40 miles per hour at the time. Both parties agree that it was 40 miles per hour. The disagreement then would be about, is going 40 miles an hour an unlawfully negligent speed in this particular location? That might be a question of law, because maybe there's a speed limit. Maybe the speed limit is 50. If the speed limit is 50, then going 40 is not speeding. And so it's not negligent. So if it's a question of law, then that's something that the judge can decide on a motion for summary judgment. If it's a dispute about the facts, then we have to go to a trial. And there's a nice picture of a jury trial. So if you look at a civil jury trial, first of all, remember the burden of proof, civil case, preponderance of the evidence. Secondly, you present your evidence, and the other side, the plaintiff presents the evidence, and the other side, the defendant, might then say, oh, I think we can dismiss this case. Well, why would that be? The defendant hasn't said anything yet. Well, maybe the plaintiff has presented all of her evidence, but that evidence doesn't get us over a preponderance. It doesn't make out the basic claim. If it doesn't make out the basic claim, you might make a motion to dismiss. And again, the judge could decide the motion to dismiss. But again, if there's a dispute about facts and the plaintiff has at least presented an issue that, if everything that the plaintiff says were true, would result in the defendant losing, then that case has to go to the jury, and so the motion to dismiss would be denied. But it might be that the plaintiff hasn't presented enough evidence of all the elements of whatever the lawsuit requires, and in that case, the motion to dismiss would be granted. Then the defendant presents whatever evidence the defendant might want to present, and then we get a motion for a directed verdict, which is basically just the same thing as the motion to dismiss. It's saying to the judge, tell the jury that as a matter of law, this is the answer. The plaintiff hasn't proved his or her case. Assuming that's denied, then we get a jury verdict. The jury then issues its verdict one way or another, and then you could get this odd thing where the judge nevertheless basically reverses the jury verdict and issues a judgment notwithstanding the verdict. Now this is really controversial because here the jury has already decided the case, has already adjudicated facts, and a judge is essentially taking that away. But the standard is a judge says, no rational trier of fact could have decided this thing. Which again is a weird thing to say because the jury just decided that thing. So you're basically saying the jury was not rational. But the idea is that it's an escape valve for the judge in a case where a jury has just gone way off the rails and decided something that's really truly irrational and not supported by the evidence. And in those rare circumstances, you can get a judgment notwithstanding. This is a picture of an appellate courthouse. So let's just take a look at the way appellate review works. We already talked about how it is that appeals courts function, and what they can review. So I'll just briefly talk about the elements of the procedure. First of all, you have a plaintiff and a defendant at the trial level. At the appellate level, you have an appellant and an appellee. And an appellant is the party that doesn't like what happened at the trial level. So it could be the defendant. So if you imagine the plaintiff wins the case on the trial level, the defendant wants to appeal, the defendant becomes the appellant at the appellate level. So the appellant is the person who wants the court to review what happened below, who doesn't like what happened below, and the appellee is the other party who is defending what happened below. At the appellate level, you don't have a trial with a jury and so forth. You have briefs that are filed on paper by both parties, and it's all a question of, was there a legal mistake in the trial level? Either a legal mistake with regard to the procedures or a legal mistake with regard to the substantive law. And so the parties file briefs, and then they have oral arguments before a panel of appellate court judges, and then the appellate court issues its decision. And as I mentioned earlier, they could reverse, or they could remand, or they could vacate the prior decision, or they could affirm the prior decision. But once that decision is reached, we are then done with the case. So once we've had a trial decision and an appellate decision, and maybe we go up to the Supreme Court and the Supreme Court says we're not going to hear the case, that case is then over. And something called claim preclusion then kicks in, also sometimes called res judicata, which is just the Latin version of claim preclusion. The thing has already been decided. And the idea here is, once there's been a full adjudication and you've had your appeal, the case is over and you can't then bring it again. So you could imagine, I sue you for breach of contract, you win the lawsuit, I try to appeal, I lose on appeal. I can't then sue you again for that breach of contract, not in this court, but not in any other court either. At least no other court in the United States, because they would give claim preclusive effect to the decisions of the first court. All right, now we're going to look at criminal cases and just the basic steps of a criminal trial. First of all, here, as I said earlier, the nomenclature is prosecution and defendant. There's no plaintiff in a criminal case. There's the prosecution, and that always is going to be the government, either a state government or the federal government, versus the defendant. The first thing that happens is you get a criminal indictment. That's kind of the equivalent of the civil complaint. It's the prosecutor saying, here's what I think happened. Here's the crime I think this person committed, and that would be the criminal indictment. That's before the defendant has had any opportunity to do anything, and that starts the process going. In a criminal case, what happens next is you go to what's called a grand jury. A grand jury is usually larger than the trial jury, and the grand jury only hears evidence put on by the prosecution. The defendant doesn't usually appear. The defendant doesn't present any evidence. It's just the prosecution's case. And so the grand jury is there to make sure that the prosecution has enough evidence that the case should go to trial. So the standard is not, is the prosecution necessarily going to win, but does the prosecution have enough of a case that this case should go to trial? And so that's when you get to a grand jury. Then, assuming the grand jury says yes, it should go to trial, then you move forward, you have whatever discovery process you're going to have, and then you go to a trial jury or a petit jury, and you have the regular trial process. And at the end of that, if the prosecution has proven their case beyond a reasonable doubt, then you would get a guilty verdict, if not, then you would get a not guilty verdict. And then you get a direct appeal. Again, there's an appeal to an appellate court, possibly a Supreme Court, and whichever the losing party is can bring that particular appeal, and then the case gets concluded. Little bit different from in the civil context. Once it's concluded, we're done under claim preclusion and res judicata. In the criminal context, if the defendant has been found guilty, the defendant has one more avenue under the US Constitution, because we want to make sure that if we're going to put someone in prison and violate their rights, we're doing it because that person was truly guilty of a crime. And so if someone is prosecuted in a state court and they have been found guilty and they've gone through their appeals in the state court system, they can go into a federal court and they can say, this state is now holding me in prison in violation of the Constitution and my constitutional rights. And that's called a writ of habeas corpus, and that allows a federal court potentially to review what the state court did, and then it can go up through the federal court system to a federal appellate court and potentially to a federal Supreme Court. So that's sort of an extra step, I think really because the Constitution is so concerned about the possibility that a state government might violate someone's civil liberties and put them in prison unlawfully. So those are the elements of the civil and the criminal trial. And as I said, there's a lot of detail in what I just provided in terms of all the different aspects of the procedure and how things move forward. So I think this is particularly a video you might want to watch a bunch of times, look at the extra material, do some of the questions and answers that exist online in connection with this video, just so you can make sure you understand both the difference between a civil and a criminal trial, and that you understand all the different procedural quirks along the way as you go through the trial process.